You're still on mute.
Sure, Your Honor. I was reminding the person in the office next door that his deposition was up very loudly. So,
Um,
thanks, Judge. So again, Your Honor, Jessica Fagan for the petitioner mother in this contempt. Thank you for hearing us today. We have another dad who's picking and choosing what parts of the order he will follow. He wants it his way. My client initially filed her petition for contempt on September 27th, 2023, regarding a 2022 parenting plan order in the related case 22 FM 6230. The first count was a failure to pay uncovered medical expenses. We've agreed that because that comes out of the legitimation order out of Fulton, we're going to table those unless Your Honor wants to hear them. But moving forward, we have two parties who were never married, and they share a 9-year-old daughter, Emerson. Your Honor, as you may recall, Emerson is a competitive gymnast, and we had an urgent hearing, not an emergency hearing, on count 3 of her contempt, where Your Honor said it's not an emergency, so I'm denying it on an emergency basis. But you did order that father stop screaming at the child as a discipline method, and you did order that the parties shall continue therapy for Emerson. So, Your Honor, and then you said you're going to set us down for contempt today. So thank you for hearing us. As I mentioned before, the parties through counsel tried to resolve these issues out of court, but we were unsuccessful, and we do need Your Honor's assistance. Count 2 is a contempt for refusing to allow the child to participate in her activities. Now, Your Honor, the consent 2022 parenting plan order provides that the parties have 50-50 parenting time. It also provides by agreement that mother has final decision-making authority on non-emergency medical, education, and extracurricular activities. Your Honor, this is a really straightforward contempt count about not allowing the child to participate. Mother claims that father is in violation. They essentially all equate to father not following mother's final decision-making authority. Your Honor, I remind you that we are here on a contempt, not a modification, so this should be straightforward. The first question that count 2 asks you to answer is father in violation of the 2022 consent order for not allowing the child to participate in activities? We believe this is black and white. Your Honor, the 2022 consent order states that the parties agree to continue the child's pre-existing activities, equestrian and gymnastics. Pretty black and white. She's going to do horseback riding and gymnastics. Then the parties agreed even further. Quote, if an extracurricular activity occurs on the father's parenting time and father is unable to transport the child to the activity, the mother shall be permitted to transport the child to said activity or extracurricular event. Your Honor, it's black and white. They agreed Emerson does gymnastics and horseback riding, and they agreed if dad can't take her, mom shall do so. So why are we here? Because even though he agreed to this order, agreed that Emerson would do these activities, and agreed that mother would have final decision-making, he doesn't like it now. He refuses to take Emerson to any activity on his time that he doesn't support. Your Honor, my client's going to testify that she does everything she can to schedule these activities on her time. But with a 50-50 schedule, that's not always possible. Things need to be alternated. Your Honor, so what do I anticipate father will argue to explain why he doesn't take Emerson to horseback riding on his Saturdays? Your Honor, and I want to be clear, we're talking about 1 hour every other Saturday morning. And if he doesn't want to, the order has a very clear resolution. Mom, you take her and bring her back. Well, first, I anticipate that father's going to claim Emerson doesn't like horseback riding. Well, Your Honor, that's a he said, she said. It's not supported by the evidence. And even if the child doesn't, that's a modification issue. It's not a basis to ignore the order. Second, I anticipate that father will say that the child is overscheduled. Again, there's no evidence to support that, Your Honor. Absolutely no third-party professional. Remember, you ordered this child to be in therapy. No therapist, no teacher claims the child is overscheduled. But more interestingly enough, this overscheduling argument is contradicted by father's own testimony. He says she can do horseback riding, just not on my time. My time is my time. And Your Honor, that's not what they agreed to, and that's not what the 2022 final consent order says. Then I think father may say that, well, I was not consulted in good faith about this, Your Honor. This is false. For one, it says equestrian and gymnastics in the order, on the face of the order. So obviously at some point, somebody talked about this and agreed to it. But more than that, you're going to see text after text, email after email of people trying to work this out. Father just wants it his way. So then, as he throws things against the wall, what's dad's next argument? Well, the parenting plan says that neither party can unreasonably get on their time, plan activities on their time, Your Honor. Again, Your Honor, it's 2 hours a month, 1 hour alternating Saturdays. There's no evidence that mother's been unreasonable. And in fact, there's evidence that she's tried to schedule it on other days and it just doesn't work. Second, the consent order clearly provides he doesn't have to take her. If he doesn't want to, he's supposed to tell mom, I can't, I don't want to, and mother shall come get the child. He has a remedy. But what has happened, Your Honor? The evidence is going to show that when mother says, the order says, I shall take her, I'll come pick her up, wherever you are, I'll come pick her up. Dad threatens to call the police on my client. Also, Your Honor, the reasonableness, the issue is he's fine with one child. He has two children with two different mothers. He's fine with one child doing cheerleading nearly every night of the week that's with him, but that's because he likes cheerleading. And also, Your Honor, you're going to hear something really interesting. He says she's overscheduled. It's not supported. He says it's unreasonable. Again, not supported. But then you're going to hear this dad goes to every activity he can on mom's parenting time. That's right. Not a competition, not an event, not an exhibition. He just shows up on mom's parenting time. So it's contradicted by his own actions. He will come and wait in the reception room while the girl's braces gets tightened, but then claim it's unreasonable for you to ask me to follow the court order, Your Honor. This is just about control. He wants things his way. So, Your Honor, my client is here because she just wants this child to be happy and not be stressed. And she knows that dad's not letting her do some of her activities. Your Honor, if he doesn't like that he agreed that mom would have final decision-making, he can file a modification. If he doesn't like that he agreed mother shall take the child to activities, he can file a modification, but he hasn't, Your Honor. Now, the next contempt in this case is about violating the term and spirit of the order, Your Honor. This is because, pardon, Your Honor?
What count are you on now?
That would be count 3 of the September 27th petition. Mother.
Count 3 we resolved, right?
No, Your Honor, that's it. Count 3 was not resolved.
Oh.
And there are also attorney's fees issues here. What you're going to hear is that there are so many evidence and issues about father just having a problem with the order. So for example, Emerson got very sick on father's parenting time. You're going to hear evidence that mother said, take her to the doctor. Dad said, I'm only taking her to the doctor if you pay for it. Mom said, fine, I'll pay for it. Take her to the doctor. They get to the doctor and you're going to hear they had a big argument because dad did not want this child to get a strep test. Didn't think it was necessary. Mom, who has final decision-making, said it's necessary. In front of the doctor, in front of the child, dad says, well, I'm sure it's not going to pay for that strep test. So she can only get the strep test if you pay for it. So mom paid for the strep test, came back positive. So then you're going to hear the doctor says this child's got strep throat, she needs to rest. And you're going to hear father decided to take her out all afternoon because she needed fresh air. But then you're going to hear father also refused to go get the prescriptions filled. He said, I don't have the money. He's got 2 attorneys here, but you're going to hear he told my client, I don't have the money to get this child's prescriptions. So I'm only going to get the prescriptions if you pay for it, Taylor. So mother says, fine, I will pay for the prescriptions. He is violating the term and spirit of the order in my client's final decision making, Your Honor. It's crazy making. It is absolutely crazy making. You don't want to have the child on an activity during your time? Great. You agreed that mom would take her. You don't want the child to get a strep test or a flu test? Fine. Voice your opinion, but my client has final decision making. It's crazy making, and we shouldn't be here because the order is very clear, Your Honor. And my client's here because she's very concerned if it doesn't stop, it's just going to continue. Now, Your Honor, the emergency petition that was filed on October 27th, that was the contempt for interfering with the health of the child. That goes part and parcel. We addressed it on an emergency basis, Your Honor, and that an urgent basis, Your Honor, and that you denied it as an emergency, but said you would hear everything now. You're going to hear that your order in November said, quote, the parents shall continue therapy for the minor child. But that didn't quite solve things, Your Honor, because you're going to hear testimony that dad is still pushing back on therapy for the child. He doesn't support it. He doesn't want to pay for it. And then, as Your Honor may recall, you suggested, look, if you can't afford the $90, sir, find somebody more affordable for you. In 2 months, Your Honor, you're going to hear he has not given one name because he is just obstructionist. He wants it his way. But Your Honor, it's not Burger King. So here's what mom wants, Your Honor. She wants father to be found in willful contempt. The order is the order. She would like the parties ordered to co-parent therapy, co-parent counseling, with the cost equally divided 50-50 so that they can try to resolve some of these things in co-parent counseling and not through litigation. And then, Your Honor, she asked that this court exercise its authority to modify the 2022 order. One of two ways. Either one, that if father fails to give mom sufficient advance notice of her shall take the child to the activity, he has to pay the late cancellation fee. Because right now, dad is refusing to take the child and mom is racking up late cancellation fees. In the alternative, she would say that if he can't keep up with this order on his parenting time, if having 50-50 parenting time means sharing 50-50 and he can't keep up with it because it's too much on him, then we ask Your Honor, look back and scale his time. That way mom will have more days that she can schedule things that won't affect his ability to, quote, chill with the child on his time. But if you're going to have 50-50, you got to co-parent and you got to pick up the slack equally. Now, also, Your Honor, their current order says it's section K, that neither party shall, quote, object to or prevent the other from visiting the child at school, extracurricular activities, or medical dental appointments. Given the dynamics between the parties and the fact that dad says it's unreasonable to schedule anything on his parenting time, we would ask that this court strike that as to dad so that he doesn't just keep showing up to all these additional activities. And yet, on the other hand, on the other side of the coin, argue that it's unreasonable and overscheduling. She also asked that this court find that, pursuant to your order in November, that therapy is, quote, reasonable and necessary under 19-615, so that father is expressly ordered to pay his portion of it. You'll
Say that one more time.
I'm asking that your court, previously their order said that if mom picked somebody out of network, that mom would pay 100%. When we were here in November, you said child's got to stay in therapy. Dad, if you want somebody who isn't costing you $90 an hour, then find somebody. It's been 2 months. He has not identified one person, and so my client is asking that therapy for this child, based on the testimony, as you recall, from the coach, the affidavit that was filed, this therapy you ordered is necessary for this child. So we're asking you to order that the costs for this child's therapist are reasonable and necessary and need to be borne 50-50 pro rata between the parties. The parties want to take it up in co-parent counseling. Again, we're asking you to order co-parent counseling. But this child needs therapy. She needs to go to her activities. And if dad can't keep up with the 50-50, then maybe he doesn't need 50-50 time, Your Honor. And finally, Your Honor, attorney's fees. My client has spent over $15,000 on attorney's fees, of which 3,365 for today. And so she's asking for reimbursement of fees.
Give me the
I
number one more.
anticipate the
Sorry,
total
can you give me-
amount she spent is 15,325. And today alone is 3,365. That's included in the 15,000 number, Judge. But
Okay.
just to give you some numbers to work with there. I anticipate that father's going to say, I'm not in willful contempt. Look, I can read some ambiguities here. Judge, semantics is not an ambiguity. We're asking for fees. He has two partners at a very well-respected law firm representing him, so I don't think there's money at issue, despite father refusing to pay for Tamiflu. And Your Honor, father also filed a counterclaim for fees under section 915.14. This was not noticed for section 915.14 fees. And as Your Honor is very well aware, we've got to have a specifically noticed hearing for you to hear that and avoid getting overruled. So if he still wants to move forward for 915.
14 motion filed.
It was filed in his answer in late October, but we never noticed it for a hearing. He
Okay.
said mom's filing of these motions was an unnecessary expansion of litigation.
Mhm. Okay.
So Your Honor, we're just trying to get back some peace, get this order followed, get these parties in co-parent counseling, and hopefully get this little girl to do the activities she wants. And as I mentioned to you, my client has no problem with language in the order saying that if it can be scheduled on her time, she has no problem scheduling things on her time. But with a 50-50 schedule, there's just only so many hours in the day.
All right. Thank you.
Thank you.
All right. Good morning, Your Honor. Damon Divick and
Good-
Suzanne Prescott. Oh. Sorry, Judge?
I said good morning.
Oh, Damon Divick and Suzanne Prescott here for the defendant, Benjamin Eccles. Ms. Fagan covered a lot in her opening statement on behalf of Macaluso, and I'll try to parcel out some of this, but I want to make sure we're focused on what it is we're here for. The evidence is going to show that Mr. Eccles is not in willful contempt of either of the parties' parenting plan or their original Fulton County order. Ms. Fagan's correct in that if you look at count 1 on the petition for contempt, that references a Fulton County order. So this court doesn't have jurisdiction to hear that because my client resides in Fulton County. He's not a resident of DeKalb County, so there's no personal jurisdiction. And then there's no subject matter jurisdiction over that issue because the order that requires him to pay 50% of uncovered medicals is a Fulton County order that hasn't been modified. So the only thing that has ever happened in DeKalb is a parenting plan that the parties modified in 2022. So I think this court is limited to hearing a contempt over issues in the parenting plan. But this court doesn't have jurisdiction at all, not personal or subject matter, to hear anything about uncovered medicals or who pays what or looking at the out of network. You know, substantively, I don't think Ms. Macaluso has a good faith argument at all because our client's issue has never been with getting his child therapy. It has to do with out of network. And the order clearly states you're supposed to use an in-network professional. And Ms. Macaluso just abuses and ignores this provision, knowing my client doesn't have the money. So she picks whoever she wants to pick, doesn't have a good faith discussion with my client, and then sticks him with a bill. But that's neither here nor there, Judge. Frankly, this court can't even hear any of that stuff because, again, enforcement of a Fulton County order that hasn't been modified when our client doesn't reside in DeKalb is not before this court. So I'm limiting our arguments to defending against whether or not Mr. Eccles is in contempt of the modified parenting plan. And what the evidence is going to show is that he's not. So essentially what Ms. Macaluso's argument is that because Mr. Eccles is refusing to take the minor child to horseback riding lessons, he's in contempt of court. That's essentially what their count boils down to. And what Miss Macaluso is not doing is coming to court with clean hands, Your Honor. She's coming to court with unclean hands because she's not following the terms of the order that she entered into. So her order, if you look at paragraph O on page 8 of the parenting plan, it says that
Can you-
neither part.
Can you share screen? You have the ability to share screen?
Yeah, I can share screen. Oh, it says host has disabled it.
Okay, Ms. Marshall, can you allow it? Okay,
At
you have it.
this, their contempt. Can you see my screen, Judge? Let me slide this over. Okay, this is their contempt. And Exhibit A has the first Fulton County order, which is not at issue today. This is what has the terms about uncovered medicals and child support and who pays what. Now, if you scroll down to Exhibit B, this is what is at issue, which is a DeKalb County parenting plan that was modified. So Miss Macaluso cites to subsection I right here, talking about extracurricular activities. And she correctly stated, mom has final say, but dad can choose one activity. The parties agree to continue the child's pre-existing activities. Mother is going to cover any expenses outside of father's choice. What she didn't do was point you to the provision of the order that she just ignores and willfully violates. So there was a check and balance here, right? And if you look at subsection O, here's the balance that says neither party shall unreasonably schedule activities for the child during the other party's parenting time. When the parties entered into this order, Emerson was
Objection, Your Honor. I don't know that we should go behind the order.
No, I'm going, when the parties entered into this parenting plan that they're seeking to enforce, this child was doing gymnastics 2 times a week for 2 hours per practice. It was taking up 2 hours of dad's parenting time. What the evidence is going to show through his testimony is how that's changed so dramatically. Gymnastics has become an extremely intensive, all-in activity, 3-hour practices per day. You heard a little bit about this last time, 3 times per week. The child is very good at gymnastics, and it's just become this all-consuming activity. Father is okay with it. He understands the child loves doing gymnastics. There have been some issues. You'll see evidence of a doctor's note that will be tendering in the evidence, Judge, where the doctor is extremely concerned.
Objection, Your Honor. Relevance.
Eating disorder.
We're not here on a modification.
This goes directly to activities and unreasonable interference with our client's parenting time, Judge, and his compliance with the parenting plan that they're seeking to enforce. So our client is taking this child to gymnastics regularly. He's not missing any practices, is not missing any of the meets. There's 3 times a week, 3 hours a day, plus 2 additional privates, plus competitions on the weekends.
I thought the issue was dealing with the horse riding classes.
Yes, and that's exactly the point. So on top of all of that, mom has then scheduled horseback riding on dad's time. So now dad's time is consumed with gymnastics on Monday, counseling on Tuesday, gymnastics on his weekends, and his parenting time is being unreasonably interfered with. And that's specifically prohibited by the parenting plan. Mom can't, on top of gymnastics, which already takes up all of dad's time, on top of the counseling, schedule another activity, horseback riding, on dad's time. That's prohibited by the parenting plan. That's unreasonably interfering with his time. What the evidence is going to show is that my client reached out to the horseback riding folks to see if other times were available, where if mom insisted on this activity, she could schedule it during her time. And they have a lot of flexibility, and mom could do that. She just chooses to control dad's times, overschedule a child to take up all of dad's time. And the other thing that we want the court to look at today in determining what mother's motives and intentions are behind this entire action. This entire action is an attempt to modify the visitation schedule. They already tried it once at the emergency. The judge summarily dismissed it. She brought up allegation after allegation about allegation. First it was he didn't wash her panties. Then it was he's not feeding her.
Objection, Your Honor. I haven't heard any of this evidence.
Then it was.
I'm sorry.
Then it was.
Mr. Biddick, no, let's not do that part.
So what we're left with now,
because the reality is that it doesn't really matter what her motive is for bringing it. If it was violated, it was violated. It doesn't even matter if she cared or she didn't care. So I don't really need to know why she is bringing it up. If either it happened or it didn't happen, right?
yeah,
So.
yes, Your Honor. Well, all of the allegations have been summarily dismissed. We're down to one. We're down to, is my client in contempt over horseback riding? And is he interfering with this child's extracurricular activities? The answer is absolutely not. He loves his daughter. He encourages all of her activities. He supports her activities. He takes them to practices. It's exhaustive. He does it. The child, she cannot unreasonably interfere with his parenting time. That's what she's doing. So there's no contempt here, Judge. So we look forward to presenting our evidence.
So it's equestrian activities and gymnastics was already considered by the parties.
Correct, Your Honor.
Your position is that because the gymnastics hours increased, that father then decided that the equestrian hours should be decreased.
Yes, exactly. And because originally when they entered into the parenting time, the pre-existing activity was on mom's time. So horseback riding was on mom's time. And then it switched to being on dad's time because gymnastics took up the rest of mom's time. So there was no more, they had to move some of the horseback riding to dad because gymnastics increased. So the day of horseback riding practice changed from mom's time to dad's. Partly.
Yeah, but the provision already has a provision for that. If an extracurricular activity occurs on father's parenting time, I didn't get a chance to go to page 3. That screenshot on page 2. Let me see page 3.
Yeah, hold on.
I can't see it. Oh, I know why. Because I'm still in my. Never mind. I know why. I see it. I was in the wrong screen. Okay, go to page 2 one more time for me, please.
Okay. Can you see it now?
I can see it. Yeah, go to page 3.
Okay.
Yeah, right there. That's what part I want.
So that is there, and then there's the check and balance of, she's not supposed to unreasonably schedule. So the circumstances have changed since the entry of this order. The pre-existing activities went from a couple hours a week to all consuming.
So you're saying question hours changed?
The day shifted and then gymnastics changed. The amount of time gymnastics takes up has drastically changed.
What was the shift?
The shift was 2 times a week for 2 hours to now 3 times a week for 3 hours plus 2 privates.
No, not
1 hour each.
The horseback riding, that's the issue. The horseback riding is the issue. That's an extracurricular activity. That's separate from gym. You can't meld them together and say, well, I'll do gymnastics, but I won't do horseback riding. He can't. I mean, that doesn't really help me. Tell me what was the change in the circumstances from that first order on the riding. What was it?
Yeah, so the horseback riding was an hour on Wednesdays or Thursdays, which mom has Wednesdays and Thursdays, dad has Mondays and Tuesdays, and it's now switched, I believe, to now it's on Saturdays, which, dad has every other weekend. So it went from being exclusively on mom's time to partly on dad's time.
Okay.
And the order contemplated that, Judge, and says if it's on dad's time, mother shall take the child.
Okay. All right.
It's
then.
about finding a balance, Judge, and we believe, yeah, our client's acting in good faith.
Okay, so let's deal with this and kind of deal with the communication piece, because that's kind of what it boils down to, based on your arguments. Let's start, Ms. Fagan, call you first.
Sure. Taylor Macaluso, please.
Mhm.
Ms. Macaluso, raise your right hand. Do you swear or affirm the testimony you're about to give is the truth and the whole truth, so help you God?
Yes.
Okay, please state your name.
Taylor Macaluso.
And how do you know the defendant in this case?
Mr. Eccles is my daughter's father, our daughter's father.
Great. You recall that you and he entered into a permanent parenting plan order?
Yes.
Okay. I am going to share my screen. If it's not large enough for everybody to see, please just let me know. Everybody see that?
Yes.
Okay. Now, Taylor, can I call you Taylor? Sorry.
Yes.
Okay. So Taylor, this is the order we're talking about today that you've asked Mr. Eccles to be found in violation of, correct?
That's correct.
Okay. Now, I'm going to scroll down it and move quickly because the judge can take judicial notice of this because this is her order. Would you please tell the court what section 1C says about joint legal custody?
It says joint legal custody is contemplated by the parent shall include joint decision makings regarding all significant matters, including non-emergency healthcare, education, religion, and extracurricular activities. The party shall consult with one another prior to making final decisions for the child as allocated in subsection D below. The party shall endeavor to choose activities for the child that can be attended by both parties and that are reasonably located near the child's school.
Great. And so when we go into final decision-making authority, tie breaking, you have education, non-emergency healthcare, and activities, but those are further negotiated, correct?
Correct.
Was this a consent order? Did you and Mr. Eccles agree to this?
Yes, this was a consent order.
All righty. At the time this order was entered, could you please read for the court? Actually, there's two I's. Would you read the second Roman numeral I regarding extracurricular activities and camps?
Starting at the beginning.
Yes, please.
Okay. The father shall be entitled to choose one extracurricular for the child at his sole discretion and cost. The parties agree to continue the child's pre-existing activities, equestrian, gymnastics, and the mother will cover any extracurricular expenses outside of father's choice.
Let me stop you right there. So what activities was Emerson doing at the time that you and Mr. Eccles agreed to this order?
She was doing horseback riding and gymnastics.
Okay. And those are specifically listed in this order?
That's correct.
Okay. Now you can continue to read.
Okay. Both parties specifically agreed to allow the child to continue to progress and participate in competitive gymnastics training and competitions as assigned by the child's gym.
Okay. What is your understanding of what that language says to Emerson's parents?
My understanding of it is that we anticipated that her gymnastics schedule would increase over time.
Now let's go to the last.
All right, let me go back to that one more time.
Ooh, here we go.
Where's it said will support your position, your party?
Hold on. Let me see if I can. It starts here, Your Honor.
Okay. Okay, let me see. Both parties specifically progress and participate. Okay. Oh, okay.
So Taylor, this was agreed language for you and Mr. Eccles, correct?
That's correct.
Okay. Now let's go down to the last sentence. If you could start with if you could read that for the court.
If an extracurricular activity occurs on the father's parenting time and the father is unable to transport the child to the activity, the mother shall be permitted to transport the child to the said activity or extracurricular event.
Okay. What is your understanding of what that means?
If dad isn't able to take her, that I have the right to take her to our activities on his parenting time.
Have you reached out to him? Well, let me back up. Has he ever told you he's unable or unwilling to take Emerson to one of her activities?
Yes.
On multiple times?
Yes.
Okay. And so what did you do?
I offered to pick our daughter up.
And what is
I would say, and offered to pick her up at any location of dad's choosing.
what do you mean by that? I'm going to stop sharing for a second.
If dad was at home, I would be happy to pick our daughter up from his home. If dad was at an activity for his other child, I would be happy to pick her up there. If dad was out doing something, I would meet dad wherever he was. And then I would drop our child off with him at the conclusion of that activity, again, wherever Mr. Eccles was and was most convenient for him.
Okay. How often does horseback riding happen?
It is once a week on Saturdays.
Okay. How long is it?
Her lesson is an hour long.
Okay. So how much time are we talking total on father's time on his weekends?
The activity is every other weekend on dad's time, so about 2 hours per month.
2 hours per month. You heard Mr. Eccles' attorney say that that's unreasonable. What's your opinion about 2 hours a month and whether that's unreasonable?
You know, I don't think that's unreasonable. In the past, Mr. Eccles has asked to schedule activities on my parenting time. Our daughter did cheerleading, and that interfered with my parenting time. I had to double up on extracurriculars. It took my weekend parenting time off, but it was something that I anticipated our daughter would enjoy. So I 100% agreed to it.
Okay. I'm going to show you what how does Mr. Eccles respond when you ask, hey, I'll come get her then for this lesson?
He either says no, he tells me that I'm harassing him. On one occasion, he told me that if I tried to show up to take our daughter to our activity, he would call the police on me.
So I'm going to show you what was submitted to the court as Plaintiff's Exhibit 2. Share my screen. Could you please identify this document, including the date of this document for the court?
Yes, it is a text message that I sent to Mr. Eccles attempting to work with him on our daughter's equestrian schedule. And I sent that to him on June 22nd of 2023.
And you've reviewed all of this before we sent it to the court. So is this a true and correct, is P2 a true and correct copy of your text message discussions with Mr. Eccles regarding riding, horseback riding?
Yes, it is.
I move to admit plaintiffs 2.
All right, plaintiffs 2. You have any objections?
No objections.
All right, so it is.
Okay. So Taylor, briefly tell the court what you're trying to do with this giant box of blue text.
So over the summer, our daughter's horseback riding lesson, we exercise a week on, week off schedule over the summer. So our schedule is a little bit different. It's a 2-2-5 during the school year. It's a week on, week off during the summer. During the summer.
Sorry, during the school, it's a what, 2-2-5-5?
Yes, Your Honor. It's a 2-2-5-5.
2-5-5, and then in the summer, week on, week off.
Yes, that's correct.
Uh-huh.
At that juncture, our daughter's equestrian lesson was Tuesdays at 3:30. I really liked that time. I thought it was a great time. Didn't interfere with any of our daughter's activities. And I reached out to dad for a couple of reasons. One is we needed to schedule a pediatrician appointment for our daughter for her wellness exam. And 2, because this would directly impact dad's time solely at the start of the school year, I wanted to make sure that dad was okay with leaving the lessons at Tuesday at 3:30. And I said, if it wasn't, that was fine. What other days worked for him?
Okay. So is this, in your opinion, an effort to resolve this in good faith outside of court?
Yes.
And what was his response to this giant blue text?
Can you, before you move forward, I'm going to read the entire text. So I have,
Sure.
okay.
Let me zoom in a little bit, Judge, to not hurt your eyes so much.
Okay.
And so Taylor, what did Mr. Eccles say in response to your attempt to figure out times that work for everybody?
He responded, please refer to the dozens of texts above about scheduling things on my time. Thank you.
And so what does that mean? What were the dozen texts saying?
Whenever I attempted to work with Mr. Eccles about scheduling anything, that was a typical response is no. And that's exactly what he's referring to, that he has repeatedly told me that I cannot, or he would not be willing to allow me to schedule things on his parenting time.
Okay. I mean, going back to plaintiffs 2 that was just admitted. Apparently opened 14 times. All right. I'm going to scroll down to the next date on this. Let's look at July 11th. Could you please read for the court what you say, starting with "it depends," and what Mr. Eccles's response was?
Okay.
It depends on what they are working on. Do you need me to pick her up? And Mr. Eccles said, for the lessons you scheduled, yes. For the lessons you forced me to allow her to do over the summer during my time, yes.
Okay. Is this consistent with his response to you
Can
scheduling?
you go back? Can you
Oh,
go
sure,
back?
Your Honor. Sorry. Roll this up a little bit so you have.
All right, thank you. Okay, you can proceed.
Okay. Is this consistent with how he typically responds to you about anything you schedule on his time?
Yes.
Why are you here today? You know, opposing counsel's made a lot about this is just about horseback riding. This is just about horseback riding. But could you tell the judge in your own words what your concern is if this continues without the court's involvement?
You know, I think my biggest concern is, as you mentioned, this is a consent order. Both Mr. Eccles and I entered this voluntarily. And we did so because we believed that the order was in the best interest of our daughter. You know, we both agreed that our daughter loves and enjoys her horseback riding. We agreed that she loves her activities. And what my biggest concern is that, you know, we entered into this consent order, and Dad's now saying that he doesn't like it. The order is there to safeguard our daughter's best interest. And it's difficult to co-parent with someone who makes agreements, who voluntarily makes agreements, and then goes back on them when he decides he doesn't want to do them. You know, I've exhausted every effort to work with Mr. Eccles. I clearly see that I asked him for his opinion on the time. When I didn't get that feedback, I moved our daughter's lesson to shared parenting time. You know, I wasn't even able to schedule this lesson solely on my parenting time. The 2 days that I have dedicated to myself for my parenting time are Wednesdays and Thursdays. Our daughter has gymnastics both of those days. On Wednesday, she has gymnastics from 3:30 to 7:30. And on Thursday, she has gymnastics from 4:30 to 7:30. Our daughter does not get released from school till 3 p.m. I have historically tried my best to put these activities on my parenting time. Even the prior year, I doubled up on my days where I put horseback riding lessons after a 3-hour gymnastics practice, which Mr. Eccles was on board with, simply to try my best to impact his parenting time as minimally as possible. I just didn't have a choice. And I'm just concerned that because I didn't have a choice and I really worked with Mr. Eccles in good faith, that he's just going to continue with anything that comes up. It's going to continue to be adversarial responses. It's going to be continued pushback. And ultimately, the person who's getting hurt by doing this is our daughter.
So going to look at, before you filed this petition, did you try to resolve this with Mr. Eccles?
Multiple times.
Okay, so I'm going to share you again. This is plaintiffs 2, just further down. Could you please read your text messages of September 5th, 23?
Good morning. The barn has moved Emerson's riding lesson to 11 a.m. on Saturdays. I believe that they removed the 1 p.m. time slot, updated our calendar to reflect the change.
And how did Mr. Eccles respond to you?
We will be busy. Again, she is not going to horse during my time on Saturdays. Please stop harassing me about this.
Taylor, to make sure I'm clear, who has final decision-making on extracurricular activities?
I do.
And which 2 activities are expressly outlined that your child will continue in your 2022 order?
Gymnastics and equestrian.
And what is the fallback if father doesn't want to take the child to the activities?
That I take her.
In your opinion, is father in contempt for not allowing Emerson to continue in horseback riding?
Yes.
Is father in contempt for not allowing you to transport her to and from horseback riding on his weekends?
Yes.
Do you believe that 2 hours a month on his parenting time is unreasonable?
Absolutely not, particularly since I have allowed for his request, I've allowed more time than that.
Did you try to work this out and put this on an agreeable time?
Yes.
Was he willing to work with you?
No.
Okay. Are you asking this court to find him in willful contempt?
Yes.
All right. Are you asking this court to award you attorney's fees for willful contempt?
Yes.
What do you want this court to do as far as, since you've testified that this is not going to be the last activity he might object to on his time, what do you think would maybe help this court solve it moving forward? What about co-parent counseling? What are you asking the court about co-parent counseling?
I think co-parenting counseling would be great for Mr. Eccles and I. I believe Mr. Eccles and I had previously discussed it, and Mr. Eccles agreed that I think it would be a great opportunity for us to get on the same page. You know, there's clearly some communication issues, and I don't want those to continue. That's not in our daughter's best interest. So I really think it would be wonderful if we could do co-parenting counseling together.
Okay. And how are all the other costs in your order shared?
In terms of everything in general?
Yes.
So for our daughter's private school tuition, I pay that in full. For our daughter's horseback riding and her gymnastics expenses, I pay for all of that in full. For her medical expenses, we are supposed to share those 50%.
So with regard to co-parent counseling, what would you ask this court to order how you and Mr. Eccles share in co-parent counseling costs?
I would just like to split it with him.
So equally 50-50?
Yes.
Okay. Have you had any expenses incurred because Mr. Eccles refused to take Emerson to horseback riding or allow you to take her?
Yes, there is a 24-hour cancellation policy. Mr. Eccles has been informed of the cancellation policy several times. Each lesson is, unfortunately, horseback riding, my daughter decided to pick, I think, the two most expensive sports ever. Horseback riding lessons are $70 a lesson. So when we don't make it to those lessons, unfortunately, because we didn't cancel, I do get charged for those lessons.
Okay. And to confirm, you've asked to take her to and from as your order requires, correct?
That's correct.
Okay. So that's horseback riding or just any activity that Mr. Eccles doesn't want on his time. Let's talk about the other contempt issues, and I'm going to kind of meld them together because they really are part and parcel the same. You've argued that Mr. Eccles is in contempt for violating the spirit and terms of your parenting plan order, as well as not making decisions about your child's health. So could you tell the court a little bit, as an example, what happened when Emerson had strep throat recently?
Let me stop you there, Ms. Fagan. Mr. Bivick makes argument that those things are out of the court jurisdiction. What is your response?
I believe that
recall the argument he made?
I do, Your Honor, I do. While I believe that there is an argument about the payment of contempt, being in contempt for the payment, she would have to bring another action. They haven't agreed to consolidate it, so she has to bring another action in Fulton County to argue for what he hasn't paid for. I do believe that under the parenting plan order, Your Honor has the jurisdiction whether or not to look at whether he's violating the final decision-making and refusing medical care and refusing to follow mom's final decision-making authority.
Okay, I got you. Mr. Bivick, do you see her distinction, and what is your position on that? Because
I think it's fair game if it's in the parenting plan order, you know.
All right, thank you so much. Go ahead, Ms. Fagan.
Sure. So Taylor, who has final decision-making authority on medical pursuant to your consent 2022 parenting plan order?
I do.
Okay. Did Emerson get sick while she was in your custody?
She
I
got
mean, I
sick.
guess recently, I guess, yes, children get sick all the time. That's an obvious question. Within the past 30, 40 days, has Emerson gotten sick while in your custody such that you had to take her to the doctor?
No, Emerson most recently got sick during dad's custodial time.
Okay. Did dad notify you?
Dad did notify me that our daughter wasn't feeling well, I think on Sunday, the 7th.
Okay, so explain to the court what happened with this, what transpired during this illness earlier this month.
Absolutely. Dad reached out on Sunday, letting me know that our daughter wasn't feeling well. The following day, her coach sent out a message to our gymnastics group me that, hey guys, flu's been going around. Just a heads up, you might want to get your children tested. Following that, I reached out to dad and I said, hey, I don't know if you saw the message, but her coach stated that she has, that the flu's been going around. And, I think it would be a great idea for Emerson to get tested. What are your thoughts?
And how did he respond?
He responded that that he did not have a problem with her going to the appointment, that he actually thought that the antivirals were effective and a good thing for Emerson. However, that he would not be willing to take her if I wasn't going to get her an antiviral and if I wasn't willing to pay for the appointment.
So he was dictating Emerson's medical care, is that correct?
Yes.
Did you take her to an appointment?
After I agreed to pay, I scheduled the appointment and Mr. Eccles took her.
Were you present at all?
I was not.
Okay, so what transpired next?
What transpired next is that our daughter had a flu test. That flu test came back positive. I then received a phone call from Mr. Eccles and several text messages about the fact that the nurse practitioner wanted to do a strep test on our daughter. I'm not a medical professional, so dad was against it. I'm not a medical professional, so I asked the nurse practitioner her opinion. The nurse practitioner was on the fence, but it came to light that dad had not informed the nurse practitioner of all of the symptoms that her teammates were having. These symptoms were laid out in our group me, and I simply informed her what other parents were reporting. And I said, here are the symptoms. What are your thoughts? And she said, given this information, I would like to move forward with the strep test.
And how did dad respond?
Dad became upset about it. Our daughter was upset. He sent me text messages that our daughter was freaking out, that she, that I guess more or less I was a horrible person for doing this. He then recalled me and tried to put our daughter on the phone while she was panicking. Mr. Eccles didn't do anything to diffuse the situation. I tried to speak with our daughter. The nurse practitioner also spoke with our daughter to try to calm her down. And at that juncture, Mr. Eccles ended the call.
And did Mr. Eccles say that link the test? I'm sorry.
Yes, could you give me one moment, please?
Sure.
All right, let's continue.
Awesome. You hadn't. Oh, wait, she's not. All right, so Taylor, you're saying he didn't want to get a strep test?
That's correct.
And so how did this resolve for your daughter?
Ultimately, my daughter did have the strep test. I just think she was very stressed out about it. The strep test ended up coming back positive.
Did you have to agree to pay 100% to get the strep test done for your daughter?
And I had to agree to pay for 100% of everything, for the appointment, for the medication, for anything to get done for our daughter that day.
Why did you feel you had to bring a contempt of court today?
It's a pattern of behavior. It starts with horseback riding lessons, and then it just kind of explodes from there. And I'm just asking for the court's help to have Mr. Eccles do what he agreed to.
Okay. Do you think if he can't keep up with the order and Emerson's activities on his time, do you think the court should exercise its discretion and scale back father's parenting time from a 50-50?
Yes.
Why do you think that would be in anyone's best interest?
Mr. Eccles has stated time and time again that his time is his time. I always do my best to try to respect that. As you mentioned, shared custody, it takes two to tango. You got to work together in conjunction. And that means scheduling things on your personal parenting time. It means working together with the other parent to schedule things on their parenting time. It's not my time versus your time. It's our daughter's time. And I respect the fact that Mr. Eccles may not want to have something scheduled on his time. And, that's his want. But if that's the case, then, I would like to have more time to schedule things on my parenting time solely without impacting dad's time.
Okay. Looking at your contempt, you also have asked for attorney's fees, correct?
Yes.
How much in attorney's fees are you asking for today?
As you stated, the total amount of attorney's fees to date is $15,000.
You, nothing subject to redirect, Your Honor.
All right. I'm going to share my screen. About horseback riding. Can you see my screen here, Ms. Macaluso?
Absolutely. Yep.
Okay. So do you recall sending this email to Ben on November 9th, 2023, the one that starts, I received a message from Emerson's riding instructor?
Yes, I received a message from Emerson's writing instructor where her instructor said that her father was attempting to change the time of her lesson.
Okay, so she said that you had contacted the owner of the barn. You're sending this to Ben, and Ben requested that Emerson's lesson be moved from her current time on Saturday to another day and time. And you said this was surprising since we haven't discussed, right?
Yes, since we had not discussed him reaching out to the barn. Absolutely.
Okay, and then scrolling up here, Mr. Eccles responded to you. And he said, Taylor, I contacted the barn to find out availability for lessons during the week, as I've stated to you countless times to you that weekends do not work for our household. I'm not sure what's confusing about that. I don't want to go back and forth on this. If I don't hear back from the barn, I'll try reaching out to other barns or trainers in the area as soon as I get a chance to see what availability there is Monday through Friday. Emerson may have to choose between gymnastics or horse, as gymnastics is taking up all of her time and leaving her very little free time to be a child and spend with family. So that he responded to you there, right?
Uh-huh.
Okay, so your prior statement that he always responds this way when he was curt isn't true, right? Because here he very calmly and thoroughly responds to you, his reasoning, and shows you the efforts he's making to try to work with you on horseback riding.
I believe that's a little misleading. There are multiple messages from Mr. Eccles within a very short amount of time. That where he also had recently sent an email to my attorney before you were representing him, where he stated that that his time was his time, that he reserved the right to not take Emerson to her horseback riding lessons whenever he wanted. I received another email during this time frame that Mr. Eccles wanted to schedule the riding lessons before her gymnastics on Wednesdays or Thursdays, and that he would take her on my personal parenting time because I couldn't because I was working. I was coaching at the gym. And so it's a misleading email because there are several others surrounding this email.
Well, the email speaks for itself. It's not misleading. It's his email to you, trying to work with you on finding another date, Monday through Friday, perhaps, to schedule horseback riding.
Correct. And Mr. Eccles also had another email that explicitly did tell me that he wanted it scheduled only before her time on the gym. I think the messages that were sent to the barn stated that the private lesson that Emerson has scheduled on my personal parenting time before her gymnastics practice was optional and that we could cancel that. And there was no discussion about that with me about canceling her private gymnastics lesson, which her gym has deemed as necessary. So yes, this is one email out of many emails that I've received from Mr. Eccles, and they all state contrary things.
Okay, so let's go up here. You then responded to his email where you said, Ben, our court order is clear on this. I have final decision-making authority on activities. Emerson loves this barn and she loves riding there. If you can't take her on Saturday mornings, I will take her. If you want to add a lesson at another barn one day a week, then you can choose that at your cost under our order. However, please make sure it doesn't conflict with Emerson's gymnastics practice schedule. I'm not going to keep going back and forth with you on this. If we don't agree, follow the order. If you don't like what our order states, then you'll need to ask the judge, because I think we agreed to about activities is in Emerson's best interest. You sent that in response, right?
I did.
Okay, and then he responded to you, right? Back on November the 13th, 2023. These are after all the text messages you showed in July and August on this issue. Okay, you remember getting this email?
Yes.
Okay, and he said, I never agreed that you could schedule activities for her during my time, nor does it state that in the court order either. So you're aware that your parenting plan prohibits you from unreasonably scheduling activities that fall on dad's time, correct?
Unreasonably, I attempted to work with dad from June through August to find a mutually agreeable time. Dad refused to work with me on that, so I picked a time independently because I was forced to, and I picked a time that would minimize the impact of dad's parenting time the least. As I mentioned before, if I could put it on my parenting time, I would. Our daughter, assuming she moves to level 4, if the schedule doesn't change, I'll have a free weekday again, and I will happily prioritize moving that lesson right back to my parenting time. This isn't a matter of me trying to impact dad's parenting time. I'm absolutely not. In fact, I've always tried to avoid dad's parenting time. This is an issue that I simply can't avoid dad's parenting time. And we're in a shared custody situation, and dad wouldn't give me options. He wouldn't allow me to keep our daughter's lesson on Tuesday during the week. And so I just had to move forward with what I thought was best.
Okay, so you're saying he doesn't give you options when on Saturday, November the 11th at 9:06 a.m., he says, as soon as I get a chance to see what availability there is Monday through Friday. So he suggested 5 other days, Monday, Tuesday, Wednesday, Thursday, Friday. Can we find any other day but my weekend to do horseback riding? And your response was no.
This was in response to several other emails I mentioned. We're referencing Mondays, Wednesdays, and Thursdays. Our daughter already has gymnastics on those days, 3 hours of gymnastics. So first off, that just completely takes those out. I had already had our equestrian lesson on Tuesdays at 3:30. And dad had told me and told our attorney multiple times that he reserved the right to cancel the lesson at any juncture. And honestly, that's not in our daughter's best interest for me to move it to dad's sole parenting time with that statement from him. If I moved it to a Tuesday, dad stating that he just reserves the right to cancel a lesson whenever he wants, at least by moving it to shared time, I was safeguarding our daughter's enrollment, at least in what I could control on our parenting time. So
on Tuesdays, dad always has her on Tuesdays, all Tuesday.
yes,
Right.
So put it on Saturday, gives you the every other. Is it every Saturday?
it's every Saturday, but because it's every other weekend, it's shared parenting time.
It falls on both of your parenting time.
That's correct.
Right. Okay, I get it.
All right, and regarding this medical issue.
So what were the gymnastic days again?
It is her gymnastics days are Monday from 4:30 to 7:30. She attends Wednesday from 3:30 to 7:30, and she attends Thursday from 4:30 to 7:30. Or it's Monday. I'm sorry, Monday, Wednesday, and Thursday, I think.
So Tuesday and Fridays are the only weekdays available, and if it's on a Friday, that's an alternating week.
That's correct. And the equestrian lesson was previously on a Tuesday, and dad wouldn't allow it at the time.
And Tuesday, the minor child also goes to counseling, is that right?
She does, that's correct.
And dad transports her to that.
Dad takes her and I bring dad at the conclusion.
And what time is the counseling?
The counseling is currently at 3:30.
Okay, so that would conflict with the horseback riding on Tuesdays.
That's correct.
Okay, regarding the medical issues, you're saying you got a phone call from someone at the gym saying a bunch of girls have the flu, and you notified Ben about this, and this was during Ben's parenting time, right?
It was actually a message in the group me that both Mr. Eccles and I have access to.
Okay, and so then you wanted Ben to take Emerson to the doctor, right?
That's correct.
And Ben took Emerson to the doctor, right?
After I agreed to pay for the entire appointment.
Okay, but you agreed to pay. You didn't say take her or else. You said take her to the doctor. He said, okay, will you pay for it? You said, okay.
I did what any good parent would do, and I offered to do whatever it takes to get my daughter medical attention.
And then now you're filing a contempt over it.
I'm finding contempt over the fact that I did whatever it took in the face of adversity. Yes.
Okay, so you have final say on non-emergency healthcare, correct?
Yes.
You asked Ben to take Emerson to the doctor and he complied and took her to the doctor, correct?
Yes.
He then called you and said, hey, the doctor wants to do more tests outside of just the flu test, including a strep test. And you said, get her the strep test. And he complied and got her the strep test, correct?
Yes.
And you're filing a contempt over it.
It's about the good faith effort of the order. And
Did he or did he not take the child to the doctor at your request and demand?
yes, I've already admitted to that.
The cost generally would, you when you said you agreed to pay, is there a what is normally the medical? Is it always on you? Are you 100% on the medical?
No, Your Honor, for in-network, her pediatrician is in-network. Those costs for any visits are supposed to be split 50-50.
Yeah, and in the Fulton County order, Judge, the Fulton County order, it does say split it 50-50, but enforcement of payment is outside the scope of this, because that's outside the parenting.
I get that, but her position, though, it sounds like, I think your questions seem to be more of the payment. And I was just trying to make sure I understand it, because her position seems to be more of that she had to tell him she was going to pay it for him to do the thing that she has a right to tell him to do. In other words, if she would have said, take him, his answer was no. At least that's what it sounds like she's saying. And I just want to make sure, are you gathering that, or is there something else that I'm missing?
Yeah, no, I see kind of what you're saying now, Judge. Well, then let me ask it more directly this way. Did you tell Mr. Eccles, you will take my daughter to the doctor and you will pay for half? Period. Did you tell him that?
Your Honor, I don't see how that question is.
Well, she agreed. She voluntarily agreed to pay 100%.
I do want to know I want to understand it. When you said I will pay, was that through negotiation? Was he saying I'm not going to take her unless you pay all of it? What was the conversation?
It was that I'm not going to get her medical attention unless you pay for it. And I felt like I didn't have a choice.
So you're not guessing that he wouldn't pay. He said he wasn't going to pay. He wouldn't unless you paid.
Yes, Your Honor. And he also said that he wouldn't pay for the prescriptions that the doctor prescribed unless I paid for them.
Okay. So I think that's within the parenting. I think that's a part of the parenting plan, because if she has decision making and the only way for her to get him to do it based on what she's saying is a part of is negotiating a bargaining, then that means that it wasn't voluntarily done. And I think that's her position. And I think that is a part of the parenting plan, which this court has jurisdiction over. All right, you may continue.
Okay, that's all the questions I have for this witness, Judge. I want to make sure my client has some time to talk too.
Okay. Any further questions?
No, Your Honor, I think you're following my client's position on this.
Okay. Who's your next witness?
No, and Your Honor, we think that it's pretty clear, Your Honor, and I'm happy to do a motion for a directed verdict to get us off quickly, do a quick close.
Well, I think they Mr. Bibbitt, call your next witness. Call your witness.
I'll call Mr. Eccles.
All right. Mr. Eccles, raise your right hand. Do you solemnly swear or affirm that the testimony about to give to the court is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you may proceed, Mr. Bibbitt.
All right, you recall entering into your modified parenting plan in DeKalb County around 2022.
Yes, I do.
And what is your understanding of the parenting plan with regards to activities?
That as far as activities go, my understanding was that she was in gymnastics, she was in horse, and prior to that, she's been changed up a lot, but she was in gymnastics and horse. Her mom wanted her to stay in that. So I agreed. I was like, that's fine. I'm good with gymnastics and horse. She's always had horse on her time. She told me when she got her into horse and when we did that parenting plan that she would keep horse on her time. So my understanding when I signed that was that gymnastics is we have no control over the schedule of that. It's team activities, and definitely understand. I agree to that. Horse was on her time, so I was like, okay, that's fine. And if we've worked together on stuff like cheer and other stuff before in tennis, so I don't have a problem with her doing horse sometimes on my time. My issue with this, and this is why we didn't put this in there, was that we didn't put in there that she could schedule things on my time because she has a history of scheduling things on my time and then saying it's in the best interest of our daughter and then making it permanent. And
Is that why paragraph O was put in there?
Yes,
You know,
that's
that talks about,
yes.
okay.
I'm sorry, Mr.
And-
Eccles, what did you just say about the horse? You said that for the I prefer to say horseplay because I can't say what equestrian. Equestrian.
Equestrian.
I can't say that. You said I don't mind it being on my time, but
Right.
aren't you saying you do mind it being on your time?
No, Your Honor. I'm saying that I don't want continuous lessons on my time where it's every Saturday during my time. That's all I'm saying. I don't mind if it's when you do private lessons, then you can schedule it at various times. When she signed her up for horse lessons in June or July, for every Saturday, I told her that wasn't okay with me. And the problem I have with it is she's had a habitual past of putting things on my time and then making it permanent. We're saying it's in her best interest to do it every time on this day. And then it'll switch, which is fine. Like it'll swap, but she's always trying to do things on my time. And she thinks that if she takes her to anything on my time, then it's okay. She says, if I pay for it and I'm willing to take her, then you should agree to it. And I've supported Emerson's gymnastics. I've supported all of her extracurriculars. I support her horse, and I have some documents to show you that I support that. My issue is her scheduling stuff on my time is when I want to be able to enjoy time with my girls on the weekends. I'm not okay with that. She was scheduling it during church originally on Sundays during my time, which I said, no, we have church at this time. She didn't change it. And then she finally changed it to Saturdays. And I was like, no weekends. I said Monday through Friday is fine. And in the fall, my other daughter had cheer on Mondays, and Emerson had gymnastics on Mondays. So Tuesdays I had free, and we enjoyed doing stuff on Tuesdays. Her schedule changed in January, my other daughter. So I'm fine with equestrian being on my time. Like, I'm fine with
So
it.
you're fine with it being on Tuesday or Friday?
I'm fine with it being on Tuesday now. Yeah. But in the fall, we had a different schedule with my other daughter on Tuesdays, and I wanted to have one day a week, every week, my girls, that we could go do stuff like have dinner, relax, enjoy the day, instead of having another extracurricular to take her to, or for her to be away. It's constant interruption, Your Honor. I don't mind her doing these things at all, but her mom doesn't respect my time at all. She never has.
I'm confused. So, because she said that on Tuesdays you told her to take it off of Tuesdays,
In the fall.
so she would have to go to. She would have to switch it up when in the spring.
You could swap. Yeah, I'm fine with it this year, like January and on. I'm fine with it on Tuesdays. But my other daughter's cheer schedule was every Monday. And so we had Tuesdays free, and I want to be able to enjoy time with my girls together.
And that's what you let her know. Like, if you look at my screen here on November the 11th, that's what you told her in this email, that you're fine with it being Monday through Friday to
Yeah.
see. I'll be reaching out to other barns or trainers in the area as soon as I get a chance to see what availability there is Monday through Friday. That's because you were fine with it being Monday through Friday after November, after the fall season was over for your other child. Is that right?
Yes.
And she wasn't receptive. She put her foot down and said, no, take her Saturday morning or else, basically, right?
She said,
Objection, Your Honor. This is the direct, and that is a very argumentative question.
Well, the exhibit
All right,
speaks for herself. She didn't agree.
Yeah, for itself. Okay.
Because, Your Honor, that's not what the order says. Like,
Well,
we're
well,
negotiating an order.
yes, I get what my job is, but my position is that I can read I can read their text. I have read it, so I know the response. I just want it, so we don't need to argue what it says. I can read it.
And you have another daughter, is that correct, Mr. Eccles?
that's correct.
And the only time the sisters, meaning Emerson, this child, and your other daughter hang out, you've aligned their weekends, their every other weekend schedule so that they align, correct?
Yeah.
What do you do on Saturdays when you have both your girls, when the sisters are together?
We used to travel a whole bunch. We go down to Hawkinsville to see my family. We go to events. We go to events in town. And then some days we just relax.
What is mandatory horseback riding on Saturdays when she demands you take her due to your ability to travel?
Can't. And I've always scheduled everything during Emerson's time around her gymnastics or whatever other extracurricular she has. She's never missed one. She's never missed one. She missed 2 lessons last year in 2023 that I can recall because I went out of town for vacation that summer. She missed lessons in the spring with her mom. She missed lessons in the summer with her mom. She missed probably 2 to 3 times the amount of lessons that she has with me. I've scheduled everything around Emerson's extracurriculars, and extracurriculars have always been an issue. That's why we put that in there on the 22nd on 2022. But my contention is that she couldn't schedule things on my time without my consent. And I've offered Monday through Friday now for the spring, and she hasn't accepted it. It's just like her way or the highway. It's always been that way.
And tell the court a little bit about how Emerson's extracurricular activities have progressed, meaning how much of your parenting time was consumed by them in 2022 versus now.
2022, she was going 2 days a week for 2 hours a day. When we signed this order, it was 20. Hold on. Let me look at my notes. I'm sorry.
If you want me to pull up your calendar to help you reference it.
Yeah, let me pull up. Well, I can just tell you. So 2020, beginning of 2021, I'm sorry, the beginning of 2022, she was going 2 times a week for 2 hours a day at gymnastics. Starting April 2022, she started going 2 times a week for 3 hours a day and 1 private lesson per day, per week. And then June 22 through well, hold on. Yeah, let me pull up that calendar. I'm sorry, I apologize, Your Honor.
All right, I'm going to share my screen. Is this a calendar that you've had from 2021 to the present?
Right, correct.
Okay, so I'm going to fast forward. Where do you want me to go to? You're in 2023, May, when it stepped up, you said?
Go down, go to like March 2022.
Okay. Here you go.
So if you look at this, you'll see she's going 2 days a week to Hot Shots. That was her gymnastics level, Wednesdays and Fridays. And she's going to horse lessons on Thursdays, every Thursday at 3:30. And if you go over to April 2022, she was going Mondays and Wednesdays for 3 hours a day. And she was going to horse lessons on Thursdays, which is her mom's day still. Her mom has Wednesday, Thursdays. And then if you go to like June or July, that's when we agreed. It was signed off on September, but when we agreed to that modification, she'll just go to say June 2022. You'll see horse lessons are still on her time every week, 4:30. Practice is still Monday and Thursdays. That was during the summer, and it was like 3-hour practices. And then if you go down to September, when the order was finalized, 2022, you'll see horse lessons still on her. She moved them to Wednesdays now, like she said. And gymnastics is Wednesdays and Fridays.
Let me something, Mr. Eccles. Since you're the two constants that the court sees is that we're working around gymnastics,
right?
And the competition, that being competitive for gymnastics, which according to the order it says you were aware that gymnastics was going to be progressive, because of course everybody understands that. And
yes,
so I think the mother is moving horse lessons around in consideration of gymnastics, or is she moving it around for some type of either convenience to her or inconvenience to you? What do you think? Why do you think she's moving the horse lessons around?
I think she's not putting them. I think it's twofold. One, because it's going on her time. It did switch to her time, which I totally get. My contention was that
I'm sorry.
I said it did. The gymnastics did move to her time on Wednesdays and Thursdays and on Mondays. In 2023, last year in April. So it was on Mondays, Wednesdays, and Thursdays. And she moved it to Tuesdays, I believe, and then she moved it to the weekends.
Now, my question is, do you think she's moving the horse around to be inconsiderate to you, or do you think she's moving them around to meet her gymnastics schedule?
I think she's moving around. She doesn't consider my time.
I didn't ask Ms. Eccles.
Yes, ma'am.
Why did she move them around? I didn't say it was inconsiderate. I'm asking you, do you think she's moving them around so that your daughter can participate in both?
I think so she can participate in both.
Okay. So you recognize she's not doing it to be inconsiderate to you necessarily. She's trying to make sure the daughter can do both.
She's trying to make sure she can do both, but she doesn't consider that I want to spend time with my girls.
Okay.
Uninterrupted, and there's constant interruptions.
After the gymnastics schedule now, the more of the time is because y'all are 50-50, wherever the schedule lands for gymnastics, that means mom is getting less time with the child to be able for that daughter can participate, right?
Yes, Your Honor.
And so right now, there's one day a month one day a week that she's involved gymnastics with you.
Correct.
And your position is that you're okay with her doing equestrian lessons, but now they must be on Tuesday.
Yes, Your Honor. I'm okay with them on Tuesdays.
So that you can have the weekend.
Yes, Your Honor.
Okay.
I needed a break for the fall. I mean, we've been going extra. It's obsessive. I mean, if I showed you text messages going back 2018, it affected my marriage because there's my daughter, put it this way, Your Honor. My daughter this summer said, why does
Objection, Your Honor, hearsay.
That's what I'm telling her what she said to me.
Okay, what did she say?
My little girl who's 4, well, she's 5
It's
now.
not a matter of it.
No, I thought you were talking about the child who was taking the lessons. Okay, never mind. So, okay, thank you. You can go ahead, Mr. Baby, if you have any additional questions.
Okay, so regarding the horse lessons, is this the text message you recognize that you sent to her?
Yes.
Okay, and you said horse wasn't on my time when we made the agreement. There was zero intention that that should be on my time unless I scheduled it or allowed it. And then you told her gym has taken over her cheer, and then it took over her tennis, and now it's taken over her horse. That's not my fault. At the time of the agreement, I did say that I wanted a free day during the week with the girls, which is what I had at that time, which you are now interrupting our Saturday in addition to her gymnastics meets, which she has been present at or during my weekends and will continue to be. So you told her, I want some boundaries. I want some free time that's not scheduled. You texted that to her directly, right?
Yes.
And in your parenting plan, it does allow you to have unfettered parenting time, unhindered by activities. That's your understanding of it, right?
I thought I'd be allowed that that opportunity to have time with my girls and not be dictated by a co-parent.
And you tried to offer her options that weren't like routine every Tuesday, every Saturday by suggesting private lessons, right? This was back in April.
She's done private lessons before. Yeah, she's done private lessons and then she's done regular weekly lessons.
Do you have concerns that your child may be overscheduled and that may be having a negative impact on her health?
Yes, absolutely.
Have you been to the doctor or gotten any evidence that corroborates your fears?
Objection, Your Honor. I believe they're about to bring in.
Excuse me, Sustained. We don't need to get into her being overscheduled right now. That's something we'll take up later.
Okay, all right.
May I say something?
Yes.
Her gymnastics schedule in the spring is about to move to Mondays, Tuesdays, Fridays, and Saturdays. So Monday, Tuesdays are my days. Friday, every other Friday.
You all can deal with that later. That's not my issue right now.
Okay. I'm fine with that though, Your Honor. Like I'm okay with it going to that. But my whole thing is, adding additional extracurricular that can be scheduled at any time on Tuesdays or whenever else, or private lessons that she has 2 private lessons, which aren't required. I think it'd be tough for her, but we've given up all the other extracurriculars so she could do gymnastics. Now it took over horse, and now she's trying to put that on my time. And I don't know if
it's necessarily taking over horse. I mean, but I understand what your position is that the concern though is that ultimately is that you all are co-parenting, and co-parenting requires just that, co-parenting. Because Mr. Eccles, your position is that you're flip-flopping between Tuesday and Saturday and now Thursday, and you're doing it because you're living, right? Like you have one daughter who's in cheer, and if it were not for that daughter being in cheer, you'd probably be completely fine with her being on Saturdays because you'll be with her on Monday or Tuesday. Or alternatively, you're concerned about Saturday now because of Tuesday. You're living. And so your lives are evolving and different things happen, and you need each other to be able to understand that so you can try to do the best that you can with scheduling. That's just the norm. That's just the norm of things, because what initially was brought to us that you didn't want the child to be on Tuesdays. Now 4 months later, you want the child on Tuesday, which means she got to flip the schedule, which is fine. You guys working together. But I don't think it's good for you guys to assume that just because someone is moving it, they're doing it to hurt you. She's clearly trying to move the schedule to meet the daughter's expectations of being able to do both, because of course she believes the daughter wants to do both. You, of course, seem like you may not necessarily believe that. I think you said earlier you didn't think she wanted to do horse.
I never said that.
I think you said that. You said you didn't think she wanted to do horse.
No, Your Honor, I don't believe I said that. No, I never said that she didn't want to
You
do
never
horse.
said that.
No, Your Honor. I think she does.
Did you say she was complaining about it?
I believe Mr. Bivik made a reference that might be, and I also did in my opening. I believe the attorneys both referenced opposite opinions in our openings, Your Honor.
Oh,
That's
okay.
where-
Maybe it came from Vivek then. Sorry, maybe that's where it came from. Okay.
I think she likes it.
The point is that, so I think you guys have to be able to talk with each other, because you're right, Miss Macaluso may not be mindful of the fact that you're trying to take in consideration your daughter's cheer and the dates that she has available. Because why would she necessarily, if you don't say, hey, for the fall, because I'm considering my other daughter, let's not do the lessons on Saturday anymore. I know previously I said Tuesday was a problem, but I prefer it be placed back on Tuesday. That's co-parenting, because you wouldn't even be here if you had just said that. I don't want Saturday, but let's put it back on Tuesday because now it's available. But no, actually I read that you didn't say that, because previously you had already said Tuesday didn't work. So now you're saying Tuesday, and she's concerned that on a Tuesday, much like you did on Saturdays, which were your days, you said I ain't taking her. So she's thinking you're going to do the same thing. Look, all I'm saying is, the long and short of it is, everybody got a reason for what they're doing, but you guys got to learn how to communicate with each other so that it all works, because you have a child that's apparently talented in one thing and enjoys another, and you just got to work. You got to have to do the best options you can. This is both of you working through it so that you don't find yourself here trying to do something that honestly 2 smart parents should be able to do. Like, this is not rocket science.
Yeah.
And you all should be able to figure out the day that you are all comfortable with regard to this. And also secondarily, y'all are 50-50. Let me tell you, there is no activities that you're going to do that generally won't fall on one of your days. Like, that's almost an impossibility unless it's like piano lessons. That's only one day a week. But when you're talking about sports, basketball, volleyball, soccer, those things require commitment, and you're not going to have something where it doesn't fall on your day. If you're thinking like that, then to some extent you got a problem, because that's not co-parenting. There's no way this child should be limited to participating in things depending on what day it falls on. You guys got to come together better than that, because otherwise, when there's one thing that, you guys want to do that falls on the other person's day, you're going to end up bickering and trying to get back, and the child is going to lose out. I just don't want you guys to be able to get to that point. I hope that you all are able to start talking and just being upfront and honest about what you're trying to do, so that you don't find yourself here, because I don't see how you can co-parent and be concerned about what falls on your day unless it's one of those things wherein you're talking about every day of the week you're running around doing something or going out of town and those sorts of things. Otherwise, you're never going to find anything with me that's doing activities that are team oriented. Because team oriented sports, they take the week. I don't know. So I think it's kind of unreasonable to think nothing's going to fall on your day. I think that's unreasonable. And because you're co-parenting. Now, let me tell you, so you'll know, Mr. Eccles, this would be a no-brainer, honestly. If you were a weekend parent and she had you every other weekend, and that's considerable, honestly, no-brainer. But you're not a weekend dad. You are a co-parent, 50-50. And co-parenting is going to involve more more defining and special where you guys got to work together or it doesn't work. That's the reason why before I do 50-50 co-parenting, I make both of the parents come to court, even though they're like, oh, we already got it together. No, I make them come. You know why? Because I need for them to understand that this is not, I'm protecting this household. I'm protecting, you can't protect households like that. Your household's got to be open because you can't foster if like, well, she doesn't need to know how much the child studies when she's at my house. Wrong, you're in the wrong game. You need to go somewhere else. You need to do some weekends and call it a day. Because if you're not going to be open about what's going on in your household so you can work cohesively, then you're not in a co-parenting situation. And guess what? There's some people who are just not good at it. They can't do it because they refuse to allow the other person to be involved in their decision making. But you cannot co-parent effectively unless you're open. That's for both of them. It won't work.
May I say something on that, please?
Yes.
I'm sorry, it was breaking up. We've never had a problem co-parenting in the past until her gymnastics schedule changed. Prior to last year, we've never had a problem. We've co-parented on tennis, on horse, on cheer, on anything that her mom wants to put her in, anything that I want to put her in. She's done a great job. I've done a great job. It was this past spring when her schedule started increasing. And in a few months, it's not even going to be an issue because she's going to be going every single day on my time except for Sundays on gymnastics. And her mom,
yeah, and that's those sorts of things you guys are going to have to deal with because they're going to change. Especially, I mean, were you not aware that gymnastics is competitive and that the schedules, you didn't know that the schedules alternate based on the levels?
Oh, absolutely, and I've supported that completely.
Well, that's what I'm saying. That's what's happening now. And so the problem is that she's still trying to do both. And that's your conversation. That's your conversation that both of you need to discuss because, you have competitive gymnastics. It is a rigorous schedule. What is she doing? 12, 16 hours a week? What is she doing? 12 hours?
What is 9 hours non-competition weeks? Well, she's doing 2 privates too for an hour. Right now she's doing.
If she goes up to every time she advances a level, I can tell you right now, the time is going to increase. Yes, so that is a real conversation that you all have to have because next year she's going to be level 5, 6, 7, and I guarantee you all that time. Like I told you previously, I know because my son is a competitive gymnast and I've seen it go from 2 hours to now it's darn near 20 because he goes every day except Wednesdays. And then all the private lessons on Sunday, I already tell you, that's a real conversation. Okay.
I don't have a problem with it.
Well, you're going to have a problem with it if she wants to do that and something else. And children do want to do other things. They are not set in just gymnastics. Like they want to do something else. And that is a real conversation. I mean, think about it. I have a son that's doing, like I said, gymnastics. And guess what? He told me the other day, well, not the other day, he's actually doing it, basketball. I'm like, you got to be kidding. There's no possible way that can happen. And guess what? He figured it out. He worked it out with both coaches. And literally, my son is goes from school from 4:30. I don't see him till 9:30 at night. I'm not saying it's good for everybody. I'm clearly not saying that. But what I'm saying is that you have to have a real conversation because now it's like, okay, which parent is picking him up? Who's going to be doing this late night homework? Like those are real conversations that co-parents have to have with each other because I can tell you it's coming up and you guys need to be able to have that real conversation. Okay.
Absolutely. We do, Your Honor. We do. And
that is, I'm not fussing or preaching at you, Mr. Eccles, particularly. I'm talking about both of you. That's a real conversation for both of you because of the sports that your daughter is interested in. And you got to figure it out. Like, some parents are okay with it because their main thing is just wanting to see her happy and they're good. And other people like to have their chill days. I don't know. That's going to be up to you as to specifically what you want. And then if you can't figure it out, then you come to me or go wherever that issue might fall. But I'm just saying, I'm just asking you guys to work really, really hard to be able to get it done without having to spend a significant amount of money and a lot of time in court, because those are just real conversations that you got to have, and try to put your daughter's desires ahead of your own sometimes. And even sometimes you may have to do it just for a bit of time. Like, for example, every year those schedules kind of change. So one year you're in good. You might only have one day a week really hits you. And then next year you might have 2 days where it hits you. It really just kind of depends. Clearly more than 2 days, but you might have that flexibility, and then you got to figure out like who's going to pick the child up, who's going to be doing the homework, that kind of thing. Those are just real conversations. That's all I'm saying. All right, Mr. Bennett, do you have any additional questions for your client?
No, Your Honor, just one. I think you hit the nail on the head, Your Honor, and thank you for that. And to that end, Mr. Eccles, would you be willing to participate in co-parent counseling to kind of talk through being, flexible and changing some days around? So it's not just like you have to take them on Saturday or I'm filing a contempt, but like you can talk about it in a co-parenting session instead.
Yeah, absolutely. We've always talked. We've never had a problem with this stuff until this past fall.
Okay, and to be fair, you have you made a good faith effort to try to work with her about making horseback riding work and coming up with some options and even researching other barns?
Yeah, that text message she posted as evidence. There were multiple text messages before that, which I referenced dozens of text messages. She didn't include those. We've had talks about horse endlessly. We've had endless talks about horse. And I really, for me personally, I just needed a break last fall from it, because I wanted to just spend time with my girls, and I was just running around. And I felt like for a 9-year-old, it was everything was increasing, and we've seen some stress too with that, with competition gymnastics, and I just felt like it was too much, and I just needed a break. And then I was fine with it. I emailed her about Monday through Friday. I emailed the
Yeah.
barn.
Let me pause you there. Do you feel like she has been a little bit rigid about demanding certain days? It will be on this day or take her or else.
Yeah, she thinks she has final say, so she enforces it with medical, she enforces it with extracurricular. I can object to anything, but she goes with her opinion regardless of what I say. That's why we put in for her to pay stuff, because she's going to do it regardless. And so I felt like the extracurricular with the horse, it was just another thing that she's just trying to enforce. It doesn't matter what I say. And so I feel kind of hopeless. And I'm fine with doing horse on Monday through Friday. I'm fine. My schedule is about to change though, where I have her every day for gymnastics.
Okay, and you're fine to talk about this issue with her in co-parent counseling to figure out a solution, right?
Yeah, but contempt isn't the way. Like, we should have figured it out. And she's just like forcing it on my Sundays during church or my Saturdays that, I have pictures of me doing stuff on those Saturdays,
Let's
events.
switch to medical, because that's the only other issue left to talk about. So on medical, what happened about this whole thing where did you hold the child hostage and say, I'm not taking her to the doctor unless you pay? Explain your perspective of what happened.
I said she has the flu. I think she has the flu. I tested for COVID, and then I said she probably has the flu. Um, and if we're taking the doctor, last time I checked, which I wasn't aware of what the medications were, but I remember like when Tamiflu was out, and we had an issue with that before, or Taylor needed to get Tamiflu, it was like $150. It was like in the hundreds. So I thought it was gonna be a lot more than what it ended up being. And I paid her this morning the $35. It was only $35 for that. But I have no money right now. I'm being taken to court by 2 women, by 2 moms, stating different things. And I had to borrow money for retainers. I have to borrow money for everything. I'm borrowing money for everything right now just to get through this. And I just, like, I can't afford anything. So I've never been to the doctor for the flu. I've never taken antivirals. So I was like, if you want to go to the doctor, then that's fine, but I can't afford it. I'm just being honest with her. My bank account's negative right now.
And then what was her? So you didn't give her an ultimatum. You just
No.
talked through your financial situation with her. Is that fair?
If you read the text, it doesn't say no. Like they said, I said no. I didn't say no. I just said I can't afford it. But if you want her to go and you pay, then I'll take her. But, and I said, I think the antivirals would be good for her. I've never taken her. I don't feel like it's medically necessary to go to the doctor for the flu. I'm glad she went because we found out she had strep as well, which that was a good thing. But I called her mom about that. You know, I included her. I didn't say no, don't do the strep or whatever. Like I called her, she said yeah, and so I went with it.
Okay,
I haven't-
and have you ever disobeyed? Like, didn't she make a final say recently about an orthodontic issue? Have you ever disobeyed her decision making on non-emergency medical care?
No. I've objected to stuff. Say I don't. The dentist said, orthodontist said it wasn't medically necessary, and it may not work. Palate is a palate expander. It's not guaranteed to work, and it's not medically necessary, but he recommended it. And I said to him, I think we submitted a text message that I can't afford $800 right now. I'm in real estate. The market's crashed pretty much with interest rates. So like if you want to do it, then go ahead. But I can't afford it right now. But it doesn't matter what I say. It doesn't matter what I say. She does what she wants to do. She's never taken my opinion on anything. Not once. If she wants to provide evidence where she said, okay, you know what, you're right. She never said that one time.
Okay. All right. I think that's all the questions I have, Judge, if we're just focused on these two issues of medical and in the horseback riding. I know there's tons of other stuff you get into, but I think the court's kind of limited us to those issues.
And also, I'm running out of time. All right. All right. Do you have any follow-up, Mrs. Fagan?
Just let me be real quickly. Mr. Eccles, you understand that under the 2022 order that you agreed that Taylor would have final decision-making authority on medical, correct?
Correct.
And you understand that in the 2022 order, you agreed to that Taylor would have final decision-making authority on Emerson's extracurricular activities, correct?
Right.
Okay. Where in the parenting plan order does it say that mother can absolutely not schedule anything on your time, quote, unless I allow it?
It doesn't say anything about scheduling.
Okay. So to make sure I understand this, it doesn't say that, but you do recall that you testified specifically that she can't schedule, you don't want her scheduling anything on your time, though. You do recall that that was your testimony, correct?
I don't want her scheduling anything that we don't agree on my time.
Okay. Do you understand how final decision-making authority works? It's a tiebreaker. Do you get that?
Yes.
Okay. So you said that there were, I think your quote was endless conversations, correct?
Yes, there were a lot of conversations on there's conversations on extracurriculars every year about different things and times.
Okay. So if there are endless conversations that you said, you just testified you needed a break from them, right?
Right.
Do you think maybe you'd get a break if you let mother have the tie-breaking authority that you agreed she could have under the order?
A break with my family? No. Mm-mm.
Okay. But with the endless emails, you just said there's texts about extracurricular all the time. Do you understand that at the end of the day, someone's got to make the call? And you understand that you agreed it would be the mother in this case, correct?
I agreed for the mother to schedule things on my time. And
Okay.
I looked up when I was making that decision, Earl versus Earl, which says which is a court case that said that a parent cannot schedule something, an extracurricular specifically, on another parent's time. And so that was my understanding. And when we made that court order, when we did that, when we made the modification, my assumption, my understanding, and my interpretation specifically was that she had horse on her time and it wouldn't be on my time.
But it
I-
doesn't say that, does it? The
It
order
does-
doesn't say that, does it?
No, it's not specific about that.
Okay. You said that you need a break, correct? You would like some weekend time to just chill,
I would like
right?
to spend time with my girls.
Okay.
And
And-
one day during the week, every week.
Okay, so you want one day during the week, every week that she can't schedule on, and you want a weekend that she can't schedule on. Is that correct?
I wanted it for the fall.
Okay. Would you be willing to agree then that this court can modify your parenting time so that you don't have 50-50 if it's too much for you? And that you would be one day a week with the girls and then every other weekend that way? But with the caveat being that only gymnastics could be on your time. Otherwise, mom has to do everything. Would you agree to that?
I disagree.
Okay. So you just basically want it your way, correct?
No, I have an opinion and she has an opinion. And
And you understand that the order provides the end of the day, who makes that tie-breaking call, and you agreed it would be mom, correct?
is it specific about being able to schedule stuff on another parent's time?
Are you asking me a question, sir?
Yes, I am. I'm replying to
Yes,
your
yes,
question.
sir. I believe it is black and white that when you give a parent final decision-making, tie-breaking authority on activities, that you expressly enumerate, including specifically these two activities, and you expressly state that if I can't take her, she can take it. Yes, sir, I do believe it clearly states that you can schedule.
Even according to Earl versus Earl.
Judge, I would like to treat this as a hostile witness and call this to a close, please, because I don't even know what case he's citing, and I don't believe he's an attorney.
So you can just skip those types of questions and move on.
Thank you. So, Mr. Eccles, to make sure I understand, you are agreeing to go to co-parent counseling like mother's asking in this case?
Absolutely.
Okay, how are you going to pay for it?
Borrow money like I have been to retain my attorneys.
Okay. And you have both Ms. Prescott and Mr. Bivik in this hearing today, correct?
Correct.
Okay.
And Your Honor, I'll just clarify.
Nothing further, Your Honor. Thank you.
We're not double charging here. You only get billed for one of our time. You get the other attorney for free. That the arrangement we've done.
All right, thank you. All right, let's come to a close, please. What time is it? I have 12 minutes to 1. I'm gonna give you a couple of minutes each, 6 minutes each, so we can stop at 1 to close, all right?
Okay. You want to go first or last, Jessica?
I'll defer, please.
Okay. All right, Your Honor. I really think you hit the nail on the head when you provided Mr. Eccles and frankly both parties advice. It's about flexibility and communication, especially when you have 50-50. That's exactly the issue. And where we've gone is we've just devolved. You know, we had two parents who were working together well, and it's just completely devolved into a lawsuit, into a contempt. And the contempt is over, I demanded you take her to horseback riding on Saturday and you didn't do it. So I'm filing a contempt. That's not a functional way to co-parent with someone. You can't do that. You don't exercise your final decision-making authority with a heavy hammer that way and then sue somebody when they send you a text message saying, you know, that's really interfering with my weekends. I can't travel at all ever if I wanted to take the girls to see an aunt. If you're demanding that I have to take this child to horseback riding every Saturday, and keep in mind, our daughter's in competitive gymnastics, so I'm already tied up virtually every other day doing something for this girl. You know, you have to look at who sued who. Mr. Eccles is the defendant. He has testified that he is ready, willing, and able to co-parent with Miss Macaluso, but just wants some flexibility. Don't take up all my time. Don't take up every Saturday. Could we change it to Tuesday? Could we change it to Saturday? He was the one trying to engage, and then she puts her foot down and files a contempt, first as an emergency over other issues that was dismissed, and now we're down to contempt over you're not taking the child to horseback riding. What I'm seeing in Mr. Eccles' testimony is this is not a man who is willfully trying to violate Miss Macaluso's final decision-making authority. This is not a man who's trying to violate a court order. His understanding of the court order is we have 50-50 custody. Our kid was doing 2 activities. I'm honoring the gymnastics. The horseback riding was on your time. We put in a clause that activities were not going to unreasonably interfere with my time. He thought that was the check and balance. That, okay, we're going to work together, but if things get out of control and all of my time is interfered with, I'd have a voice. I'd have an ability to say, hey, Miss Macaluso, this isn't working for me. All my time is getting taken up by activities. Can we compromise? Can we figure something out? Can we take a step back on horseback riding? And that's where the flexibility and the communication comes in. This is not a willful contempt. This is someone that's not respecting the spirit of the order. She's guilty of the exact conduct she's complaining about. When you have joint legal custody, you're supposed to have good faith communications with the other parent. When you have 50-50, it's even more important. You don't make decisions and mandate I'm doing it on a Saturday. And then when the other side says, how about Monday through Friday? What are some other options? Well, I'm going to sue you for contempt because you didn't take her on Saturday. You know, it'd be one thing if Mr. Eccles, if there was evidence presented where Mr. Eccles stubbornly and rigidly just refused, but that's not what the evidence showed. There were text messages and emails exchanged where he gave her other options. And that was, you could see that in the November 2023 email. How about Monday through Friday? How about we do private lessons so that it's not every week? How about we try a different barn? I can call around. And then she says no. So, and then files a contempt. And then spends $15,000. I mean, think about how that could have been used for gymnastics, for a 529 plan, for educational resources, for tutoring, for school, for anything other than a contempt, for co-parent counseling. That could have paid for years of co-parent counseling. And now my clients had to spend $5,000 on us defending about this. This is not holding Mr. Eccles in contempt when there was no willful desire to violate a court order does not set these folks up for success. It empowers and endorses Miss Macaluso's posture of my way or the highway, take her on Saturday, and if you don't, I'm filing a contempt. That's not co-parenting, Your Honor, and I don't think that would set these parties up for success, and I don't think Mr. Eccles, Miss Macaluso has met her burden of proof that Mr. Eccles has willfully violated a court order. He's trying in good faith to work around a child that has a lot of activities and protect his time, just have some chill time, be able to travel, be able to do things that aren't so scheduled. So that's our position, Your Honor. We ask that you would dismiss this contempt and order that the parents go to co-parent counseling to continue working on flexibility and communication, because I'm not seeing a man who is just refusing to take this child to gymnastics, who is just refusing to take this child to horseback riding. What he's asking for is a little bit of flexibility and communication, and what he received was a contempt. So that's our position, Judge.
All right, thank you, Ms. Fadden.
Thank you, Your Honor. Mr. Bivik made a valiant argument, but you heard, Father. You saw the text messages. You saw the emails. Is there an order? Yes, there is an order. Is that order clear and unambiguous? Yes, Your Honor, that order is clear and unambiguous. And was there a willful? Now, Mr. Bivik can say that he's just trying to work it out. He's just trying to work it out. But Judge, you heard the father and you saw the exhibit 2. Good morning. The barn has moved the writing lesson. I've updated our calendar. We will be busy. Again, she's not going to horse during my time on Saturdays. Please stop harassing me about this. Your Honor, Yes, once he got attorneys, he tried to clean it up a little. After the contempt was filed, he tried to say, well, what about any of these other days? But then, Your Honor, you heard him. First, he was, well, I just need my Saturdays. I need my days. Okay, let's put it on Tuesdays. Well, no. Tuesdays are my days too, and those won't work, Your Honor. You heard him. Do not schedule on my time unless I allow it. Your Honor, that's not what the order says. There's got to be a tiebreaker. And 50-50 parenting, as you eloquently said, is a 50-50 shared blessing and burden, essentially. You know, his attorney said he did not stubbornly and willfully refuse. Yes, he did, Your Honor. He admitted, he said, she schedules, quote, all my time. His attorney said, we need to protect his time. Your Honor, you're a parent. It's not his time. It's not my time. It's the kid's time. Now, can it be unreasonable? Yeah, don't be unreasonable. But they put up no evidence that this is unreasonable. What we have is an order that says this little girl is actively involved in at least 2 activities. 3, if you really read it, Judge, in their consent order, they mention tennis, equestrian, and gymnastics. 3 activities mentioned. Most parents just throw it out there, activities. Here, we got 3 activities enumerated. These parents knew this little girl was active and engaged. But no, now that the rubber meets the road, Dad wants it his way and to protect my time. It's not his time. It's this little girl's time, Judge. You know, opposing counsel said something about, well, we just need them to have good faith communications. But what did his client testify to? Endless talks. We go back and forth on this all the time. Well, yeah, they do. They have those good faith communications, apparently endlessly, according to Mr. Eccles. But what Mr. Eccles, the circle is not hitting the square because he doesn't understand, apparently, final decision-making authority means you can go back and back and back. At the end of the day, there is a tiebreaker. He doesn't like the order. He wants it his way or the highway. You know, he wants to go to Burger King and order it my way, but that you cannot do that in a 50-50 time, Judge. So my client is asking you to look at to modify the order, say that, to quote you, you can't protect households in a 50-50. You must be open to work together cohesively. You can't protect my time on a 50-50. And so if Dad wants to protect his time, as he testified he did, then my client is asking, modify this order and take away some of the time, make him every other weekend in order that she can't put anything except gymnastics because they all pair agreed that she's going to do gymnastics on his time. But it's crazy making to say that this child should be limited in what she wants to do when she has 2 great parents because Dad needs to protect his chill time. Your Honor, it's a contempt. Is there an order? Yes. Is there a violation? Yes. Is it willful? Absolutely. You saw his texts. You heard his testimony. Mother's asking for attorney's fees. She has spent quite a lot of money to get this child into therapy and to try to preserve it. Because as she testified, it might just be horseback riding now, but this dad is very clear. My time, you can't touch it. And so, Your Honor, either find him in contempt and or modify the order and give him the limited protected time he wants. Thank you, Your Honor.
Okay. So the order, of course, is what's controlling. This is a contempt matter. The matter is whether or not the order was violated. Whether or not the child is overscheduled, whether or not there should be some changes to her schedule to meet their scheduling. Those things are not before the court. And perhaps there could be some modifications. I don't know. But the reality is that for this particular order, I do find Mr. Eccles in contempt. And here's the thing. And I think, Mr. Eccles, I really want you to listen very carefully to how this order is set out. Okay. And this is important for you.
Okay.
It specifically contemplates contemplates that you all were aware that this child was going to be in competitive gymnastics and that you were comfortable with moving your schedules for that purpose. It specifically says it, okay? So if you look at the order in and of itself, and I don't know if you have it in front of you because I'm kind of looking at a screenshot of it, it says that both parents specifically agreed to allow the child to continue to progress and participate in competitive gymnastic training and competition as assigned by the child's gym, indicating that you're giving the control of the competitive of this schedule so this child can compete to the gym, which means mom doesn't have control over what days that's going to be, and that no one is doing it to be in control over the other person. The date where they fall is where they fall. I think, Mr. Eccles, you're okay with gymnastics. You understand she likes it. You understand that there's a lot going on, and you're fine with that. I think the problem comes in with the equestrian not competition. I'm not sure what I think lessons, and that the problem is trying to figure out where that fits in as she progresses. See, that's a modification issue potentially, but it's not dealing with what you're dealing with now, because in that order, it says you recognize that she will continue to do them. You said it, okay? And so to the extent that there are changes in the circumstances that make that order iffy or concerning to you, you had to do a modification. You just can't decide, well, I don't like it anymore. So she's not going to go to horse lessons anymore, because horse riding lessons anymore, because it's just too much. Because if it's too much, you need to do something else. You just don't stop going.
Yes, Your Honor.
Okay. And that is very clear. It says that you are both, she's going to participate in them both. And you know that the gym lessons are going to get more extended because you already contemplated that. Now, the concern then becomes with Miss Macaluso is that she then tries to place the horse lessons on Tuesday. And your position is you objected to it. At some point, you then, I guess you reconsider and you're like, Tuesdays now work. I definitely don't want Saturdays. And those are things that you all obviously can kind of figure out to make it work for both of your households. So I'm not saying that your request is unreasonable, because from season to season, things change. Our households change, right? That's the part where you got to kind of work through each other to make sure it happens. But Mr. Eccles, if you get to a point, though, when you are telling the parent who has the extracurricular final decision-making, no, you're not going to do it, then honestly, at that point, she probably doesn't have any trust that you're going to do it on either day. And what she said was that made sense to the court. At least Saturday, I can control some of it. Because if it's on a Saturday, she knows she can at least make two. If you deny the other days, she has no control over it. She can't make the child go there. She doesn't have the child physically, and she would have to hope that you take the child, even though you've already indicated you don't like it. And so she's concerned. So that's why she put the child on Saturday, so she could at least get the child there twice a month if you said no, right? And that's why she did it. It was a strategic decision. And it was done strategically because she was concerned that you would say no on Tuesdays. And when you said no on Tuesday, guess what? There is no fallback. Like, it's just done. Whatever Tuesday you decide to do, that's because you're not communicating, you're not trusting each other. So that's why it didn't get on a Tuesday, because she didn't trust you would take the child on a Tuesday. And when you say no, she doesn't feel like she can motivate you to do it when you're supposed to. So that's why she moved them on Saturday. Now, that to me, like I said, is something you guys need to talk through. But the real issue before the court right now is, was there a decision already was there a schedule already contemplated? And it was. Now, the overscheduling, I don't think this is overscheduling. 1 hour every other Saturday to me is not overscheduling, okay? Because, wait a minute, hold on now. Because she has, okay, no, because one Saturday, I think, so basically it would be almost all of your Saturdays, right? So do you have a free Saturday?
No, Your Honor.
Okay, so it's every Saturday, so 2 times she would make it. So yeah, you would have to do it every other Saturday. Like I said, I don't think it's overwhelming. It's only an hour. I think though, however, it becomes overwhelming potentially when you think about the extended hours of gymnastics, because even though you contemplating it and actually feeling it, make things very different. Because you can say, yeah, I don't mind her doing competitive. And then it turns from 2 hours to 4 hours to 6 hours to 8 hours. Now, horse lessons are not as important because it's clear she's doing this. Maybe you have to give and take on some things. I get that. I really do understand that causes you some alarm, and that's something to discuss. I just don't think that you do it under this order. And that's the problem. You did it under this order when she specifically brought it to your attention that you were supposed to take the kid to the lessons and you didn't do it. That's the issue. The other issues dealing with the I don't know what case law you're reading about. It can't be on your time. So maybe that was what they call the 20% time you're doing every other weekend or something. I'm not really sure. But as I've already indicated to you, when I envision somebody who's co-parenting, especially when you have half the week, I don't know how you cannot schedule on somebody else's time. I just don't see how could it work? Yes. Could you do something? Can you find an activity where it can only be on mom's time and an activity that can only be on your time? Sure, but the likelihood of someone being in team sports like that is just unreasonable to me. I don't understand how you can't have a situation where it's going to fall on somebody's time. The issue is working together, because that's what y'all signed up for. You signed up to work together so that your child can be cohesive. And you can't be cohesive if you're not working together. So long story short on that is that I think that you have to understand she has the final decision-making authority under this order, which means that as long as she's reasonable about it, she can do it. But I don't think that means that, everything falls on your day and she's being unreasonable. Her days are free. It depends on what sport it is and what y'all agreed and what is customary and what is, reasonable in your household. I don't think it's unreasonable because it was, in this case, simply because it was already contemplated. And now with regard to the medical issue, I get it. You are struggling. You are financially struggling. Unfortunately, for this order, there are other ways that you could have handled that. You could have said, I cannot afford to pay it now. It'll be something I have to pay later. That would be fine. If you don't have, she wanted you to take to the doctor and they wanted $100 copay and you don't have $100 copay, you just don't have $100 copay at that time. But you can't condition it like I'm never going to pay it. You could say, I don't have it today, but I will pay it later. I don't have the money in my account now, but that doesn't mean I'm not going to pay it. And what she got it was the demand, like either you pay it or the child isn't going. And that to me is you can't do that, because then no one would pay, these medical bills, because they would always say, well, I just don't have it. And that is something I will deal with later if we have a contempt issue, but you cannot mandate it based upon, if you don't pay it, then I'm not going to take her. This is your child's health and well-being, and mom has the final decision-making authority on it. You have to do it. You take the child, you tell mom, I don't have any money right now. You gotta have to pay it up front. I'm gonna have to pay it back to you later because I don't have it now. That would have been completely fine. And I would have been okay with that, and you would not have been in contempt. Because everybody falls on a circumstance where they may not have the money in their pocket right then and there. And another parent does, and you'll work through it. As long as you're not doing it willfully, then you're not going to be held in contempt because it's not willful. You don't have the money, right? And so I don't have the money right then, but I will have it later, or let's work out something. But condition it on taking your daughter when the child is sick and mom, who has the final decision-making authority, has indicated this child needs to go to the doctor. It is what it is, and that's what you had to do. You failed to do it, so that I do find you in contempt on that. So the court's position on the attorney's fees, I'll take a look at it. I need to see the affidavit, Ms. Fagan, and the billing, and I'll take a look at it and I'll make a decision with regard to the attorney's fees. Ms. Fagan, if you would do an order to the court, leave that attorney's fees area blank, I'll fill that in once I take a look at your affidavit. That's the order of the court. Y'all are free to leave.
Of course. Do you want findings of fact or do you want me to keep it simple?